Well, hello, good afternoon. Good afternoon, guys. Listen, I have to apologize. I have to apologize to you guys first because I don't know, apparently I can't tell time today. And I wrote 2:00, I wrote 2:15, so sorry for the late start for those who thought it was at 2. If you miss the next, let's see, 6 minutes, sorry for the early beginning. If you think it's at 2:15, my bad. It's totally on me. Anyways, so this is office hours, and we haven't held an office hours for several months, but just because there are there's a lot of action going on in the Donna Adelson case right now, I just wanted to touch base with you guys, touch base with everybody who is in the Justice for Dan Markel community, and say hello and just make sure that we're all up on the same page, right? So there's a few things that I want to get to in our time together today. The first of it being just a general review of the docket. The past couple days, there have been several filings, right? So I just want to make sure and go through and show you guys everything that's been filed in the last week or so, ever since the motion to suppress and the motion for bond were denied. And then after we review the docket, I want to go through the deposition of Wendy, because she has a deposition that the defense would like to take. So I have some thoughts on that. And then finally, we can get to the motion in limine, which was filed by the defense. So let's get right back into it. But first, let's say hello to the first few people in the chat. Of course, we have Ms. Judy at AA Legal Focus. If you guys are not not subscribed to Judy's channel, make sure you are. She has some really good things going on over there. She is an OG in this community. And she's been covering this Dan Markel case and all the ancillary issues for several years now. We have Kenor Spielman. Hello, hello. Of course, we have Top Cat, 88, always in the house. So appreciative of you, Top Cat. Judy says she has to drive an appointment. Okay, that's fine. That's cool. Replay crew, you can hold them down. Hi, Cheryl B. Nice to see you. Welcome, welcome. All right, you guys, let's get into the docket, which I have right here. Listen, Judy, that's fine. You're the one who's here. Judy says mentor, lawyer, and fancy fiction were first, and true lifestyles. I wasn't naming everybody who's in the space, but you're here. You're in the house. So that's why I named you. All right. Let's get into this. All right. Here we have, I think it's big enough for you guys to see. The docket entry. Can you guys see this? If you can't, you'll see that on March 3rd, 2025, that's when Judge Everett denied Donna's motion for bond. And previous to that, on, well, I guess it was the same day, he also denied Donna's motion to suppress any mention, basically, of that call, the hot mic call, where she's talking to not Charlie on the recorded line. All right, so after that, we get a lot of orders to transport, and those are orders requesting that certain people who are in custody of the state prison system be transported. Those were up. I'm pretty sure I did see those up, but it doesn't look like they're linked any longer. That's kind of the problem with these. Sometimes you see them and then the next day, poof, they're gone. All right, here is, this is a motion to transport a witness on March 7th, and they were asking to transport Katie McBanoa, Catherine McBanoa, for a deposition. Apparently they were having some trouble. They were trying to get inside the jail to depose her, but the jail said they're not allowed to have any electronic equipment, including a stenographer's equipment. The stenographer is the court reporter. So they are asking Judge Everett for an order, attention the jail where Katie is, to transport Katie to the courthouse so that she can be deposed by Donna's counsel. All right, this one, where are these opening? Hold on. Okay, so we'll see here. This is Katie's notice of taking deposition. There's another one. Oh, that's the amended one. This is a pretty robust one. This is notice about scheduled depositions. We have Pat Sanford here. He was the detective on the case. Sarah Latoure. I can't think of who that is off the top of my head. If somebody knows in the chat, drop it in there. Was that the realtor? Maybe Wendy's realtor? Can't remember off the top of my head. Mary Hull, she was the financial analyst for the state. She went through the all the finances, the bank accounts and stuff of the Adelsons. She testified in the prior cases, the prior trials. Top Cat says Top Cat says, I use a magnifying glass to read the documents. Is that because you can't see it on my screen, Top Cat? Do I need to make this bigger? I don't know. Also interjecting, Cheryl B says, I'll always enjoy listening to you and AA Legal Focus. Thanks, Cheryl. And Marcus, always in the house. Thank you so much for being here. Good day to you as well. Okay, Judy says that Sarah was the victim's advocate. She was the one who Wendy said, we look alike, or we have the same skirt, or something like that. I that's who I'm remembering right now as the victim advocate, the one who spoke with Wendy in that police interview. All right, so Mary Hull, we know who Catherine McBanois is. Jason Newland just testified the other day. He's also a state witness in the prosecutor's office, I believe, an investigator. Lisa Carey, don't know. Maybe that's the realtor. I'm not sure. Tim Kelly, also. Does that ring a bell? Tim Kelly. Hold on one second. Let me see if I can find out who that is. Yeah, I'm not seeing that in a quick search. And then Chris Corbett, who also put together some states' documentation. I believe he did some of the cell phone tower stuff and put together a lot of the documentation that was presented at the trials, just showing, cell phone things and towers and stuff like that. So I'm kind of surprised that all of these depositions are being scheduled, though, because I recall Donna's new counsel saying there's not very many depositions that they need to take. Maybe they had a change of heart. Okay, Top Cat and Judy at AA Legal Focus are confirming that Lisa is the real estate agent. Okay. All right, good. So we have those depositions that are going to be starting as early as next week, all the way through mid-May. Let's see what else we have. 246. We also have the depositions that will be taken for Francis McBanois, who is Catherine McBanois's brother, as well as Jerome Obed, who was, I don't know if they're still in touch at all, Charlie's friend and roommate, I believe. So those are interesting. There is an interview with Francis McBanois, I believe, but he has not testified in any of the trials yet to date, and neither has Jerome Obed. So, it really seems like they're trying to get any morsel of information from any of these individuals. Those depositions are going to take place in my neck of the woods down in Fort Lauderdale. So, and those will be happening on April Fool's Day. All right, let's see. Let's see, what else do we have? What's this? We have a transcript that was filed, a transcript of the motion hearing. That transcript was from the hearing on Donna's motion to perpetuate testimony. where she names the two young ladies, Cassidy and something else. I can't remember her name right now off the top of my head. Where she's talking about these two ladies who were also in jail with her and also happened to be in jail with Katie McBanois. And they overheard Katie saying something. Brittany, thanks, Judy. Maybe you should just come on right now, Judy, so you can help me with all these names that I don't know. But that motion was denied. Donna was arguing that these ladies, once they get out of jail, they will go back to a lifestyle of, narcotics, and they will be unavailable for trial. Judge Everett wasn't buying that argument. So he said, just find them and do a regular deposition with them. He's not going to compel them to appear for a perpetuated deposition. All right, the next depo notice that's on the docket is this one. So here we see Wendy's has been noticed for a deposition March 21st. So that's like a week from now in Austin, Texas. So if you fail to believe the rumors up until now, this is probably pretty good proof that she actually is somewhere in and around that area, but certainly not in the state of Florida anymore. Wendy Adelson's to appear March 21st for a deposition. The state of Florida, Sarah Dugan or Georgia Kappelman, will not be in attendance in Texas. They will appear via Zoom. Now, the last time Wendy was, I'm assuming a subpoena is going out to Wendy, right? The last time that happened was in Katie's trial. Katie wanted to depose Wendy Adelson, and Wendy was not having it. So I think what I want to do is I want to show you what went down in Katie's trial when Katie tried deposing Wendy. Wendy got her lawyer, John Laura, to file this motion for protective order. I'm not going to read the entire thing, but I think there are some points in here that we are likely to hear again very, very soon, given the upcoming date of the deposition. They give a background of, what's happened in the cases. They say Adelson is a witness in this matter. Indeed, the state previously served Wendy Adelson with a subpoena to testify at Rivera's trial before he pled guilty, which automatically conferred use and derivative use immunity on Adelson's anticipated testimony. Now, this is what this is all going to be about, her immunity. Let's see. On April 19th, 2019, McBanois counsel served the subpoena on Adelson, which sought her testimony on May 10th, pursuant to FRCP 3.220H, for a variety of reasons, including the baseless efforts of certain witnesses to unfairly incriminate her. Adelson's counsel has advised Adelson to assert her rights under the Fifth Amendment to the United States Constitution and Article 1, Section 9 of the Florida Constitution, hereinafter constitutional rights, in response to any substantive questions posed during a defense-compelled deposition in this matter. Adelson has decided to follow her counsel's advice and will assert her constitutional rights under such circumstances unless she obtains the protections afforded by Florida law. Now, those protections that they're talking about are the protections whereby the state can confer on her immunity. Now, they could do this if they want to depose her or they are also able to do it if the defense deposes her, but the state has to issue that immunity. So let's move on. Adelson's counsel has informed McManus' counsel that Adelson will assert her constitutional rights at any defense deposition in this matter, since her testimony would not be protected by statutory immunity. Because McManus' proposed deposition would unnecessarily inconvenience, embarrass, and harass Adelson, she respectfully requests that this court quash the subpoena. So let's see what the judge did. This is the order granting Wendy Adelson's motion for protective order. So it's ordering a judge that the motion be granted. It is undisputed that upon being called to testify at deposition, the witness, Wendy J. Adelson, upon advice of counsel, will assert her right to remain silent pursuant to the Fifth Amendment of the United States Constitution. The defendant's assertion that the witness should appear and have to claim her Fifth Amendment rights as to each question would serve no useful purpose. So the state had responded and said that this was just a blanket objection. Like you can't just have a blanket invoking of the Fifth Amendment. You have to actually go to the deposition, and there's going to be plenty of questions that you can ask, plenty of questions that you can't answer, rather, that she can answer, plenty of questions that would do nothing to incriminate her. All the background information, facts, like actual facts, those would not incriminate her. That was the state's position in this motion. But the judge said, no, she doesn't have to even show up because she's already said that she's going to plead the Fifth for anything, for everything. Goes on to say, and this was Judge Hankinson, by the way, the assertion of one's constitutional rights is not admissible at trial and would not be relevant for any purpose. So that's basically saying the defense couldn't come into trial and tell the jury that we tried deposing Wendy Adelson and she pled the Fifth every time. Can't go into court and do that. There can be no doubt that the witness, Miss Adelson, does have a legal basis to assert her rights to remain silent as to the circumstances of her husband's death. And that was signed in May 2019. So in Charlie's trial, she was not, they did not attempt to depose her. Instead, she was being called as a state's witness. So they asked to put a statement on the record. Although it's, immunity is, I forget what the word is. Immunity's automatic, basically, if the state is going to be calling the person. They still wanted to take the step to put it on the record, place a statement on the record that she's only testifying pursuant to that immunity. And if she did not have the immunity, she would not be testifying. So that's what they did. Here, let's go through this really quickly. Let's see. We don't need the background. Memorandum of Law. Adelson will testify pursuant to the state subpoena. Remember, this is Charlie's trial. Absent a state subpoena, Adelson would invoke her rights under the Fifth Amendment to the United States Constitution and Article 1, Section 9 of the Florida Constitution. As a result, Adelson requests that once the state calls her as a witness, Adelson's counsel should be allowed to place on the record a statement outside of the presence of the jury that 1, Adelson intends to invoke her Fifth Amendment rights. 2, Adelson's testimony is entitled to use and derivative use immunity under Florida Statute 914.04. And 3, use and derivative use immunity extends to any testimony given during defendant's cross-examination of Adelson. Given the state's theory of the case, there is no question that Wendy Adelson, has a real and substantial interest in asserting her rights against compelled testimony. In these proceedings, Adelson has thus made an unequivocal and complete invocation of her rights under the U.S. and Florida constitutions. To ensure full protection of Adelson's rights, she requests the opportunity to state on the record her entitlement to these important constitutional and statutory rights. Therefore, Adelson respectfully requests permission to make a trial record of these matters as outlined above. Now, in Charlie Adelson's trial, they did not try to depose Wendy. So that's why they're making that statement on the record. Now, as far as I know, they didn't. I fully expect something to be put on the record. I fully expect a motion to be made, a motion for protective order to be filed in Donna Adelson's case. I think we'll see it any day now, possibly. Wendy doesn't want to testify. Wendy does not want to be deposed by the defense. I mean, she doesn't want to be deposed by anyone, but certainly not by the defense when being deposed by the defense is not going to give her any sort of immunity. So, the historical actions of her, I believe, will inform our future expectations of what's to come. All right, so that is that for Wendy's deposition. The last thing that I definitely wanted to get to was the motion in limine, which is here. This was filed yesterday. And we'll take a look at that right now. All right, defendant's motion in limine, court file from dissolution of marriage. Mrs. Adelson has been indicted in this case with one count of first-degree, let me make this a little bigger, with one count of first-degree murder, one count of conspiracy to commit first-degree murder, and one count of solicitation of first-degree murder. The state has listed as Exhibit 60, divorce filing, indicating their intent to admit the entire court file in Adelson versus Markell, a Leon County case from 2012. By this motion, Mrs. Adelson moves to exclude and or limit State's Exhibit 60. Discussion. Although Section 90.2026 Florida statutes permits a party to ask a court to take judicial notice of court files, the contents of the court file and the documents contained therein must still be admissible. The contents must be relevant. Additionally, documents which contain hearsay are still inadmissible. In Stoll versus State, the court held that although a trial court may take judicial notice of court records, it does not follow that this provision permits the wholesale admission of all hearsay statements contained within those records. We have never held that such otherwise inadmissible documents, because they're hearsay, are automatically admissible just because they were included in judicially noticed court files. To the contrary, we find that documents contained in a court file, even if that entire file is judicially noticed, are still subject to the same rules of evidence to which all evidence must adhere. So the divorce file from Wendy and Dan's divorce contains over 560 pages. It's significant that Mrs. Adelson was not a party to the divorce proceedings. Okay, so that's true, but let's go on. There can be no credible argument that the vast majority of documents have any relevance to this proceeding. By way of example, summons, notices of unavailability, motions in order for telephonic testimony, notices of depositions, requests for production, responses to requests for production, notices of filing deposition transcripts, orders directing mediation, notices of mediation, mediator reports, notices of hearing, notices of subpoenas, etc., etc., etc. They clearly wanted to type out every single type of document that was in the divorce file. Okay, so yes, it is a lot. It is a lot. And a lot of it, probably, they're right, is not relevant to the proceedings. The only significance the undersigned can fathom is that the state desires to use the size of the divorce file to support their false narrative that the divorce was a bitter custody battle. Those documents, which comprise the majority of the exhibit, do not survive a relevance analysis in any way. In seeking admission of the divorce file in previous trials, the state has asserted that the statements contained in certain filings go to motive of the defendant then on trial. Although such an argument could overcome the relevancy issue addressed above, the state must still establish their admissibility as either an exception to hearsay or as non-hearsay. Regardless, the state of mind exception to the hearsay rule does not extend to the admission of the divorce file in its entirety. Significantly, the state of mind of the declarant is the subject of the exception in Section 90.8033 Florida statutes, and it applies solely to the declarant's state of mind rather than the state of mind of defendant. The declarant is the person who is speaking, right? For example, in Bailey versus State, the defendant's first-degree murder conviction was remanded for a new trial, so it was reversed, because hearsay statements of the deceased victim, which tended to establish a motive for the alleged crime, were obviously offered to prove the state of mind or motive of defendant, a purpose for which the hearsay exception created by Section 90.803A does not apply. So in that case, the victim said something and it was allowed, it was admitted. The victim's not there, right? So hearsay is an out-of-court statement offered in court to prove the truth of the matter asserted. So if the victim, who is unavailable for court, obviously, has said something, then that's going to be an out-of-court statement. Well, I guess the trial court in that case allowed that statement in against the defendant, but on appeal, it was reversed. With respect to Mr. Markel's March 26, 2014 counter motion for enforcement, and by them naming this specific document, I think this is probably the document that worries them the most, right? So with respect to that document, a counter motion for enforcement, the motion contains 8 specific requests. Only one of these requests apply to Mrs. Adelson, namely the motion identifies statements allegedly made by Mrs. Adelson to or in the presence of her 3- and 4-year-old grandchildren. Her 3- and 4-year-old grandchildren later allegedly repeated those statements to Mr. Markel. Now let me go down to footnote 5. Oh, never mind. It's just... Okay. Footnote 5 says the state has previously referred to this 16-page motion, not including the exhibits, as the mother-in-law motion. We know that motion, right, you guys? I've done a video on it before. A little over 1 page of this 16-page document, plus the prayer for relief, concern Mrs. Adelson. There is no relevance to the remaining pages of this motion. Even if any of the remaining issues are relevant, they does not survive a Section 90.403 balancing, as their probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. So, statements purportedly made by Mrs. Adelson are admissions. So, in that mother-in-law motion, we know that the grandchildren, the 3- and 4-year-old, told Dan, their father, that Donna told them that Dan was stupid. And I'm just going to ad-lib a little bit. Stupid, dumb, sloppy, an idiot. She hates him. So the 3- and 4-year-old go back and tell their daddy, Dan, and then Dan wrote those comments in the mother-in-law motion. That's basically what went down, right? So statements purportedly made by Mrs. Adelson are admissions. However, statements made by her grandsons to Mr. Markel are hearsay. The statements in Mr. Markel's court filings are also hearsay. So this is, in other terms, in legal circles, called hearsay within hearsay or double hearsay. It's when there's a statement within another statement, and they're both being offered in court to prove the truth of both statements. So the first statement would be what Donna told to the grandsons. Your father is dumb. Your father is stupid. I hate him. And then the second layer of hearsay, the second statement, is Dan putting those quotes inside this mother-in-law motion. So it's hearsay within hearsay. With respect to the alleged statements repeated by the 3 and 4-year-old grandchildren to Mr. Markel, and which Mr. Markel placed in the court file, there are 2 levels of hearsay the state must overcome for the documents to be admissible, like I just explained. Even if there is an exception for one level of hearsay, there is no exception for the second level of hearsay. In Nowak versus State, the court reversed the defendant's second-degree murder conviction, where the trial court permitted a detective to testify to what a co-defendant said the defendant stated about shooting the victim. The court recognized that what the defendant said to the co-defendant was an admission. However, there was no valid hearsay exception to allow the detective to testify to what the co-defendant said to the detective. Now, I'm wondering if in that case, maybe the co-defendant didn't take the stand, because that admission would have been admissible as a statement against the defendant's interest. Maybe they didn't take the stand, so they brought in the detective to testify as to what the co-defendant told him. That's not allowed. The state has previously argued that Mr. Markel's statements in the court file were not hearsay pursuant to section 90.8011C, because they are not being admitted for the truth of the matter asserted, but rather go to the defendant's motive. Simply stated, the statements go to the state of mind of the listener. In such circumstances, statements by Mr. Markel, Dan, in his countermotion and other filings would not be hearsay to establish Mrs. Adelson's state of mind if the state can establish Mrs. Adelson knew the statements had ever been made. Let me read that again. In such circumstances, statements by Mr. Markel in his countermotion and other filings would not be hearsay to establish Mrs. Adelson's state of mind if the state can establish Mrs. Adelson knew the statements had ever been made. Absent evidence establishing Mrs. Adelson was aware of Mr. Markel's March 26, 2014 countermotion, the state cannot admit that motion as substantive evidence in Mrs. Adelson's trial. So, what does that mean? That means that one of the exceptions to the hearsay rule is state of mind, right? The defendant's state of mind. So that would be Donna's state of mind. If there's an out-of-court statement, a hearsay statement, like something written in a court file or something that, grandchildren told their father, if that statement was heard or known by the defendant, in this case Donna, then that could go to show Donna's state of mind. And in that way, it would be admissible as hearsay. So the question is, did Mrs. Adelson, did Donna know about that March 26, 2014 mother-in-law motion? Now, that's been a question that was raised at Charlie's trial. And it was talked about multiple times at Charlie's trial. Like I said before, it's funny that they're only pulling out just that one motion. There were a lot of motions in the divorce file, but they seem most worried about that motion. In that motion, that's where Dan Markel is asking the court limit Donna Adelson's access to the grandchildren. because he said she is, she's turning the grandchildren against him, against their father, by saying things like this, by putting these ideas in their head. So he was asking the court to not allow Donna to have access to the children by herself. I mean, as a grandmother, as a grandparent, yeah, I would be infuriated. That would be infuriating, right? Hearing that the father of your grandchildren doesn't want you to be able to spend time alone with your grandchildren. So let's go to this, because I have this queued up. Let's hear what Wendy had to say about it.
Mine were not venomous.
Okay. Did your mother, Donna Adelson, review the filing in which Dan Markell is accusing you of this theft and all this stuff?
I don't remember if she did.
What about the one where Dan Markell is asking that your mother not be permitted to have unsupervised visitation with the kids?
My mom never saw that, because after he filed that, he then asked my parents to babysit the kids. My mom baked him banana bread, gave him a hug goodbye. So there was nothing truthful about that pleading that he filed, and my mom never saw it.
Why do you think he filed that?
He was really angry at me for leaving him.
Okay, so he didn't really want to limit your mom's visitation with the kids.
No,
and
he
that's
asked for her to
evidenced,
babysit after he filed that.
Evidenced by the banana bread. And so she didn't even know about that filing.
She never knew about it.
Okay. And when she laid all those options out in that email to you about other options that you could take to secure the relocation, as far as bribing, remember that? Converting the Christian children to Christianity, remember that suggestion?
I sure do.
Okay. What did she put in there that she viewed as your most non-negotiable and most important part of your divorce?
I don't know. Do you have something I can see?
States Exhibit 57. And it is page 1. Page 1, paragraph 2.
So you want me to read what she said here?
I want you to answer the question. What was the most important part
Of the divorce for my mom.
Yes.
It says here that for her it was relocation.
Okay. And then again.
Notion that Dan Markell seeks to enjoin you from allowing your mother from spending time with the kids without supervision.
Can you please show me which page that's on?
450. Do you see a paragraph beginning on 3 specific occasions?
Yes, I do.
Could you read that, please?
8A, on 3 specific occasions in November 2013, the children informed Mr. Markell, Abba, Dad, Grandma says you're stupid. When queried as to why Grandma, the maternal grandmother, would say such things, the children replied jointly that it is because she says you are trying to take her sunshines away from her.
And continue, please.
In December 2013,
you don't have to say the name. Your child.
My child, the younger son, further stated to Mr. Markell in front of the former wife, Abba, Grandma says she hates you. The children were visiting with their grandparents at that time.
Mr. Markell is concerned that continued exposure to such negativity forms a foundation for parental alienation. Is that what he was alleging about your mom?
That is what he is alleging in this document, yes.
And this was filed in court?
He filed this in court.
On what date?
It will be at the front of the document, right?
Yes, ma'am. Page 441.
This was filed on March 26th, 2014.
And this was the filing that never got ruled on, right?
I don't believe there was any ruling on
And
this.
that's because Dan Markell was killed before the hearing, right?
I don't know when it was scheduled for.
It wasn't even scheduled yet.
Okay.
It was waiting to be scheduled when he was killed. Is it fair to say your mom was worried about this motion?
No, my mom never knew about this motion. And as I mentioned before, Danny asked my mom to babysit after filing this motion. So I don't really believe anything that's written here.
Well, you forwarded this motion to your mother
I don't believe I
via
did.
email. In fact, you forwarded this motion to 12 different people. Your mom, Jeffrey Lacoste, Renee Griggs, Tova Walsh, Morgan Honeycutt, Gary Cohen, Miguel Edmondson, Trey Hubler, Robert Adelson, Rachel Frank, Jared Reich, and some MEHULNYC@yahoo.com. So if you weren't worried about this, why'd you send it to all these people?
I couldn't really say. It's been a long time.
And then a couple days later, we know what happened.
So this was in March. So a couple days, I filed it, I sent it to people in July when Danny
You
was killed.
sent it, I'm sorry, you sent it a couple days later.
I sent
That email to 12 different people.
in March.
Yes.
Y'all, is it as infuriating for you guys to watch this as it is for me? Oh my goodness. She is just, I don't know how she does it, man. Neither does he. Neither does he. Wow. I mean, I every time I watch it, I'm just so awestruck by how dumb she tries to appear to be. I don't understand, and I don't know, is there something I could look at? And I don't know if she saw this. I don't know if she saw that. But yes, she never saw this. She never saw this. And how do we know? Because Danny asked her to babysit? What is the connection there? Because she baked banana bread for them? For her sunshines? Because she gave him a hug? You ever hear about people stabbing somebody in the back when they're giving them a hug? That's the reasoning that she has, that she states multiple times, how she knows her mother didn't know about this mother-in-law motion, aka Sunshine's motion. And then when faced with the truth of the fact that it was sent, her mother sent it. I mean, she emailed it to her mother and to 12 other people, a dozen people. Her only explanation is, it was a long time ago. I don't remember. And then Daniel Rashbaum comes in to save the day, to release some of that tension. And what is he talking about? For so long, I wonder, what is he objecting to? Why are they doing a sidebar right now? Well, I looked at the transcript, and the sidebar was him bellyaching and complaining that he didn't have a copy of the emails and the documents that Wendy was reading at the time. Yes, it was provided to them. Yes, he had seen them, but no, he didn't have a copy of it in front of him. So he didn't know what email they were talking about, blah, 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 blah. I mean, he just made a whole big thing. Obviously, he was just coming in to save the day, to get her off the hot seat, to get Wendy off the hot seat. It's just so infuriating. It's just so infuriating. I don't know what to do. I mean, I just want to scream. I don't know how you guys handle it. So, let me see. Anything else about this motion. Oh, let me just tell you, I guess, my prediction for it. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this motion in limine, enter an order excluding and or limiting admission of the court file from Adelson versus Markel, the divorce file, and for such further relief as is just and proper. And then we have that certificate of good faith conference, which now is required to happen under the Florida rules as of this year, a certification that you've conferred with the other side. So we have that, and we see that the state is objecting to granting this motion, obviously. So where do I see this going? I don't know if Judge Everett is going to try and throw them a bone and say that the entire file can't come in. There are a lot of extraneous documents in the divorce file that really don't have much to do with this case, in my opinion. But I don't know if he's going to require the state, pick and choose everything out. That might be the case. And I think they had to do that, actually. I want to say something with Corbett and his testimony. I feel like at some point back in Rashbaum days, I feel like he was arguing to limit the scope of some evidence that was being admitted at the trial, and the state had to go back and kind of pick and choose which ones they wanted to bring in. Really, that's just going to take some time. That's just going to take, somebody in the state time to have to pick and choose through the file. There's a lot of stuff in there, though, that we know Donna was keeping abreast of. We know Wendy was keeping her informed and in the loop of everything that was going on in the divorce filing and in the case and in post-divorce, the custody hearings and et cetera. So we know Donna knew about all that stuff that was going on. So it's a little disingenuous to say that, oh, she didn't know anything about that because she made banana bread, y'all. I can't because she made banana bread. Unbelievable. So yeah, I don't know. I think Judge Everett, he may throw them a bone and tell the state to pick and choose some of the most critical documents. It's possible. But the entire thing's not going to get thrown out. So that's really all I have. Oh, you guys who have stayed till the end, I'm going to throw you a little gem, and you guys are going to be the first to know it because I haven't heard anybody else talk about it. You know how the Adelson family has been putting things in trusts for years now? Their assets in trusts, their properties in trusts, and who knows what else in trusts. There's a new trust. And I happened to find it the other day. If you don't know what you're looking for, though, it might be hard to find. Now, typically, people put things in trusts for safekeeping, right? For privacy reasons, for safekeeping. And it's very common for trusts to be named something logical. Like, if I was to create a trust, I would call it the Misha Janice Trust, the revocable Misha Janice Trust dated March 13th, 2025. Something, because often there's multiple trusts, so it makes sense to title your trust something that makes it easy to find when you go back and look for it, right? So we know Wendy moved to Texas, somewhere. And we know that her property, her condo in Miami Beach, was owned by her. She had purchased it in 2021. Well, I don't know exactly when she moved to Texas, but I think it was after she moved to Texas. Um, she put the condo in a trust. And she created a new trust to put that condo in. Not sure what I can show you guys. So there's some addresses on here. They're P.O. boxes, though. I think I should be okay with that, right? I think so. Let me share this with you. All right. So, warranty deed between Wendy Adelson, a single woman with a post office box, blah, 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 and the trustee of the Wendy Revocable Trust. Just the Wendy Trust. Dated September 16th, 2024. This document was filed, one second. I'm gonna look at this without showing you all the information on there. Although it's a public document, I guess I have to be a little bit careful. This was recorded November 1st, 2024. And it was signed in October of 2024. And it was signed by individuals with addresses in Austin, Texas, and Round Rock, Texas. I'm not going to show you that part because it does have their addresses, which I don't know if they're business addresses or personal addresses or what have you. But yeah, one of the witnesses is Sabrina Berger, and the other one is Ramakrishnan Sundararaman. That's my best guess. Don't come for me. So, yeah, we have yet another trust. Do you remember in Charlie's trial where Wendy said, one day we'll change all of our names? This is when she was being asked about changing her son's names from Markel to Adelson, which she did after their father died. And she said, one day we'll change all of our names. Is this possibly the beginning of that? Just leaving her name off entirely, the name of a revocable trust? That seems very, very odd to me. Unless it's intentional. So if somebody tries looking for the Wendy Adelson Trust, this wouldn't come up. So that's all I wanted to share with you guys. Let's go to the comments. Let's see what you guys have to say. Oh man, I gotta scroll up. Let's start with this. Yes, Mentor Lawyer had Francis McDaniel, Katie's brother's interview on his channel. That's where I saw it. I should have known that it was there, that I saw it. That's a whole nother little deep dive that I'm not even going to get into. There was some shenanigans with Katie's sister-in-law who was convicted of embezzlement, I think. Yeah, that's a whole other sideshow. So Top Cat says Jerry Obed doesn't really know much as far as I know. I don't know. How do you know what he knows, Top Cat? Has he spoken with somebody? Has he talked to anybody? And like I said, Donna's probably looking for any little morsel of information that could help because there's so much evidence, so much admissible evidence against her at this point that they need anything. They need anything. Although when Jerry was deposed, Charlie was still free. So he was deposed. I always felt that he knew more, but was acting like he never saw or noticed anything. Maybe that's possible. Bichon Mama. Hi, Bichon Mama. Dr. Obed was in the hot tub for starters. Problematic. Surely Sigfredo's lawyer will advise him to plead the 5th. That's also possible. I think that deposition passed already. I don't remember what date Sigfredo was going to be deposed, but I think it's probably occurred already. Oh my gosh, more talk about the hot tub. Well, not any longer, Top Cat. Top Cat says, Obed seems to be able to stay under the radar. Not anymore. We'll see. If he has any little thing, any little morsel of information that could possibly help Donna, we're going to see him in Tallahassee. Bet. Yeah. Yeah. It really was a huge divorce file. I think the entire file was in that white binder that that Wendy had to go through. This one right here. Wait, can I not? Hold on. Okay. This big white binder. I think that is the entire divorce filing. It really was huge. We all know. Yeah, agreed. We all know Donna was very involved in the divorce. A moment to pray. Conquer Affair 2. Lord Jesus, I hope we get Wendy arrested this year. Amen. Yes, Wendy 2025 is a thing. Stay tuned. Stay tuned. Yep, you're right. NCA bet. You called it before it played on the screen. It was emailed to Donna and a dozen other people. Donna definitely knew about that motion. Deborah Jacobs says, go, Misha. That's right. I'm going. Yep. Yeah. Beyond infuriating. So beyond infuriating. Like, it's hard. And the thing is, I really want Georgia Kappelman or whoever is going to be examining her, taking her direct. Man, I really want them to stay on top of her and not let her get away with so much indifference, so much forgetfulness, the I don't know and I don't remember, or it was a long time ago. I really, really want like more leaning into that. Now, granted, I don't think the jurors need that because she came off how she came off. And I think we know how the juries felt about her. It's just, I don't know, needing to see her not be rescued, for one, like Daniel Rashbaum kept trying to rescue her whenever Georgia Kappelman was cornering her. that's my request. If I could request one thing of the prosecution, it would be to nail her down a little bit more. Thank you, Anne-Marie Moyer. Everyone hit the like. I love this show. Hello to all. Thank you. Thank you so much. Yeah, I never remember to ask people to hit the like button, but now that you're reminding me, everyone, please hit the like button. I really appreciate that. Thank you for being here. Here we go. There's my ticker. I'm terrible at that. Listen, 2025 is going to be my year. I'm going to remember how to do this. These YouTube things, I'll become a little more official, maybe. We'll see. Where was I? Donna went to the relocation hearing when it was denied. Yes, she was all up in that divorce file. And let me tell you, if you don't remember from the video that I did when we went through the divorce file and the final marital agreement, Donna Adelson signed it as a witness. If you don't remember that, go back to, let me see. I don't even know what video it was of mine. It was when I was really getting into, hold on, let me see if I can find it real quick. Relocation motions, maybe? Yeah, I don't remember which one it was. Oh, no. Okay, it was the marital settlement agreement. Yeah, it was from last June. So hold on a second. This one. Oops. I can't even show you the thing. I don't know. Sorry guys. I don't know how to do this computer. Anyways, Donna Adelson signed the marital settlement agreement. So she's right up in there. She was in the thick of it. Okay. All right. Yes. Yeah. I got to pay the people for showing up. Okay. So I hope you enjoy that. I hope you enjoy that. Topcat says, great find. I think she changed her and kids' names at the time she moved to Texas. Interesting. I have looked, but I have not seen anything to support that assertion, Topcat. If you know of anything, do tell so that we can, so that we can all know about it. She did sign this warranty deed, which was in October. She signed it with her legal name, Wendy Adelson. So at that time, she was still Wendy Adelson. I have checked just to see if I find anything, but I haven't found anything yet to date. So I wonder if Janice Scott says, I wonder if Wendy changed the names of her boys on their Social Security checks. That's a good question, but probably because they were legally changed. She did go through the process of legally changing their names in court in 2015, I think it went through. So probably. Conqueror Fear 2 says, Wendy is so deranged, destructive, and diabolical. The 3Ds. It's just that she has a pleasing exterior, so it's very covert. I mean, I guess that depends on who you're asking. Probably pleasing for many, but definitely not most. We'll see. It'll be interesting to see her face. come Donna's trial. Yes, Top Cat. Indeed. Indeed, she was. Hold on. Let me see if I can find that real quick for you. It's so good. All right, here we go. Okay, so I'm going to share with you. I haven't even played this, so. For the relocation, the Adelsons are spending so much money and it's not fair. Donna was behind all of this. And we see that because look who signed as Wendy's witness. Donna Sue herself. Right there next to Wendy, along with Wendy's attorney. She was right there the whole time, happy to sign on this dotted line to end the marriage that Wendy had gotten herself into. So that's all right. So there you have that. Yeah, go back. That was 9 months ago. It was called Adelson versus Markel Divorce Files, the Marital Settlement Agreement. That was the title of that video that I did, going through the whole agreement and showing, like you can see, that Donna signed as a witness to that. Beach Chillin', hello. Hey, have you ever looked at the lawsuit Charlie filed against Fitzpatrick? No one ever talks about it. Where was that filed? What jurisdiction was that filed in? Is that Ryan Fitzpatrick? Probably because it ended. I think it was very old, right? I think that was a very old case. All right. All right, good folks. I'm gonna let you go. That's all I have for you today. So thanks for joining me. I appreciate you taking the time out to come to my neck of the woods. And, I'll keep you posted next time there's some action. Again, look out for something from Wendy. That should be coming soon, I would think, just based on, the historical data. If that comes, I will go live and let you know what it is. Or I'll post it in my community tab so that you can see it. All right, so that's all I have for you guys today. You take care. Have a good one. Thanks for joining me. Bye.